Hey, everybody. Welcome back to Realtime Immigration. I'm really happy to be joined today by two guests. I have Kristin Whitaker and Melissa Warburton here with me, and they just launched a new firm called Whitaker and Warburton after long respective careers at USCIS. And they were gracious enough to lend me a little bit of their time today and come on, talk about their work at USCIS, their work now in private practice, and some of the trends that we track very, very closely, and all the listeners know quite well around EB-2 NIW petitions, EB-1As, O1s, and more. So Kristin and Melissa, welcome. Thank you so much for joining me today. I really appreciate it.
Well, thank you. We're excited to
Yeah.
be here.
Thanks for
So
having us.
I want to give you both the opportunity to talk a little bit more about your backgrounds and do it more justice than I did, because you guys have both had like very, very long and interesting careers. And we've talked, off the record before, and I've learned a bunch from both of you already. And so I want to share that with the listeners. But let's start by just level setting and letting them know a little bit about each of your backgrounds. So Melissa, do you want to kick things off and maybe talk about how you got started in immigration law, and then sort of what brought you to USCIS and then brought you out into private practice again?
Yeah. So I started my career. I was a law clerk in the Northern District of Texas. I worked with all the judges there and really got an inside look on federal district court, which was just like drinking out of a fire hose, but was a really incredible experience and initially gave me exposure to just the federal court system, as well as immigration cases, because they handle the immigration cases. I did a couple years in private practice where I was a trial attorney. I was mentored by someone his name was Jason Thomas. He unfortunately has passed away, but he was one of the best trial attorneys in Texas, in my opinion, and just really learned a ton from him. But then, my calling was always, I really wanted to work for the government. So I had the opportunity to join Immigration and Customs Enforcement as an associate attorney, and I worked there for a few years. It was during the Obama administration. It was a very different vibe than it is now. And it was, it was court every day. I also did a year where I was the enforcement and removal operations in bed attorney. So I was managing the detained NTAs, et cetera. And then in 2016, a lot of things changed, and I decided to pivot out of Immigration and Customs Enforcement. And there was an opening at the Texas Service Center for for counsel there, and I moved over to the Texas Service Center, and that kind of started my career in the business immigration world. And we worked primarily with EB-1As, NIWs. We did a lot of litigation. We do a ton of litigation support there. And so, I worked there from 2017 until about 5 months ago, when I was able to have the honor of launching this practice with one of my good friends who I worked with, Kristin. So we've been really focusing on business immigration, a lot of EB-1As, a lot of NIWs and Os.
Yeah, absolutely. You guys came into the market at the right time, that's for sure, because there's a lot of volatility there.
Yes.
Thanks for that, Melissa. Kristin, can you give the same background for you?
Sure. So I started in a big law firm. I got put in their immigration department. I wanted to be a trust and estates lawyer, but it was the summer after September 11th, and they canceled the summer associate class, and they had one opening, and they gave it to me, and it was with a very difficult immigration partner. And I learned, I cut my teeth on H-1Bs and old perm cases. Perm was just launching. So that dates me a bit, but and then I had the wonderful opportunity to move to the AAO in 2008, where I worked on all kinds of cases, including the EB-1A portfolio, NIWL, and then eventually the Danisar case and the implementing decisions after Danisar. And then my husband got transferred to Texas, and I switched from headquarters at USCIS to the Texas Service Center, and eventually joined OCC, where I worked with Melissa. And like she said, we worked with the EPIC team, which is the I-140, basically the I-140 team. I was on the I-140 working group, and sort of in connection with a lot of the OP&S and headquarters folks in driving I-140 policy and litigation strategy and things like that. So,
And it was a very busy time, especially the last
yes.
5 years on that front. And maybe that's sort of what we can kick things kick things off with. Melissa, you mentioned, being immigration attorneys inside of USCIS, a part of your portfolio was dealing with the litigation, right?
Yeah.
That was coming against USCIS. Maybe describe and talk about what the day-to-day of that looked like for the team, for you and for the whole team of attorneys that you worked with at USCIS.
Yeah. So what's interesting about USCIS is the Office of Chief Counsel, OCC. That's the acronym we'll keep throwing out. Is not forward facing. So with Immigration and Customs Enforcement, the private bar kind of has access to the trial attorneys, but at USCIS, I would describe our role really a lot as in-house counsel, and I think that that's an accurate description because USCIS kind of the model of USCIS is a little bit like private corporation, right? I mean, it's self-funded, et cetera. And so we were like in-house counsel, and a huge component of what we did was litigation. So whenever individuals sued the agency, the first person to review the lawsuit is the Office of Chief Counsel. They kind of rotated out who got, if it was a Texas Service Center case, it would come to our specific office, and we would look at the lawsuit. Sometimes certain individuals have a little bit of expertise in one area, so they might kind of focus on certain lawsuits. But for the most part, it was kind of just like a rotational wheel, and we all took turns getting different kinds of federal lawsuits. They ranged in the mandamus, the typical mandamus agencies being too slow. But the real meat of what we did were APA actions, where people were challenging both the regulations and challenging the legal sufficiency of the denials themselves.
And Kristin, you alluded to it in the introduction of your background, but there were some big changes on the I-140 and particularly the EB-2 NIW front over the last couple of years as a result of litigation. And I'd love to hear from your perspective, because I've heard sort of this story 100 times from 100 different immigration attorneys who are practicing on the outside. But I'd love to hear sort of the story from you both on Danisar from inside of USCIS when you were there.
So when I joined the Danisar team, it was still being developed as a case, as a decision coming out of AAO. I worked for Irene Riccio, who was a phenomenal attorney and who became an immigration judge in Miami. And she kind of led the team, and some of the folks that were part of that team are still at OP&S. But it ultimately just became a shift from the old standard of NISDOT into this new framework. And then we developed all these implementing decisions. And the idea was that it was supposed to make it a little bit easier and sort of modernize the idea behind national implications of national interest waivers and not make it as regional or geographically focused. Also, it was supposed to promote STEM. There were all these initiatives that, Danisar was supposed to widen the group and make things a little bit easier. And so I think it did that for a while. The thing about NIW from a litigation perspective is that it's by statute discretionary. So the agency has the discretion to sort of shift its policy, and there's not a whole lot that the courts can do or say about that. And so that we didn't litigate a lot of NIW cases in federal court because there is no subject matter jurisdiction over the actual merits of the case. There's procedural issues, like sometimes the procedural issues can come about, but from when we were on the inside of the agency, we didn't see a lot of litigation surrounding NIW because of both of those things, because there's no federal court jurisdiction and because there's such a high approval rate. Nobody sues over an approval. So it's interesting to see it now. And I actually have particular passion over some of these decisions that are coming out of USCIS that I think are really outside the bounds of where Danisar was supposed to be. And we like to tell our clients that, and we like to structure our cases so that we're kind of anticipating their arguments. Like we see this a lot. We see decisions coming out that say, well, Dr. Danisar had X, Y, and Z, and you don't have X, Y, and Z, so therefore you're not qualified. And that's such a distorted view of how a precedent decision coming out of the AAO is supposed to work and how the Danisar decision is set up. So
we talked about it, and you guys attended the Immigration Data Summit that we did yesterday. So you've seen the data on it, but the sheer increase in the number of EB-2 NIW petitions that were being submitted to USCIS starting in around 2021 increased a lot. It used to be around like 5,000 per quarter. And then at its highest point, 9 months ago, USCIS reported receiving 20,000 EB-2 NIW I-140 applications. I imagine over that 4-year period, the types of cases, and Kristin, were you at the AAO, remind me, between 21 and 25 at all, or were you?
No, I was at
Okay.
OCC.
Okay, you're at OCC then. I
Mhm.
imagine these conversations, were part of your work regardless, though. But the types of petitions that were coming in must have gotten a lot more diverse, presumably, with the volume overall increasing. Um, Melissa, maybe you can take this one first, and then Chris, I'd love to hear your take on it too. Like, what were the internal conversations like at USCIS when this one visa type, the EB2 NIW I-140, that had traditionally had pretty consistent numbers with the EB-1A, for example, all of a sudden skyrocketed, and you were getting 3 to 4 times more per quarter per year, that USCIS then had to manage. And again, I imagine there's more denials, more challenges to those denials, et cetera. What was that like?
I mean, I'll talk a little bit, just speak to a little bit about just the logistical challenges of something like that. So, USCIS is a government agency and moves slowly and has a hard time reacting to things like this. In part, too, and this is particularly true with USCIS, it takes a long time to onboard a government employee. You have to have background checks, you have to go through multiple screenings, et cetera. So, it's not like the workload suddenly rises and they're able to hire a bunch of adjudicators. I mean,
Right.
these adjudicators have to then go and get trained, and they have to, it just takes a long time. So when you see a huge spike like that, it's hard for the agency to pivot because they're constantly, as any practitioner knows, constantly dealing with massive backlogs, and they're constantly shifting their adjudicators to kind of whoever, whatever portfolio is in the most need of immediate work at that time. And the NIW is not the most complex form, but I think any of the business immigration forms where there's an element of discretion is a complex form to adjudicate because it requires the officer to just have a little bit more training on how to review the evidence and whatnot. So on that front, I think it was incredibly challenging to see the workload just kind of skyrocket. And I don't know, there was a lot of different ways. There was a lot of training that went into it. One of the things OCC does is a lot of training for the officers, particularly on legal writing and legal sufficiency, in hopes of avoiding those kind of crazy decisions that we'll see and we still see. So there was a huge pivot with regard to that. Kristin can probably speak more to the internal conversations with the teams.
I mean, one thing that I think is fascinating too is that the officers have a union, and the union contract requires them to have a rotation. So they were able to rotate in and out of
Mm.
teams regularly. And so you would get a team trained up on a really difficult form type, and then their employment contract would say that they're allowed to then rotate to something that's a little less intense. So you have this constant flow of folks being trained and then doing the work and then leaving and then being trained and doing the work and leaving. It's a really hard business model to create depth with. But that being said, we did see a lot of crazy decisions. We tried to provide training to the officers, and a lot of writing training. It's interesting to me, occasionally we'll see a decision, mostly in EB-1A context, where the decision is coming out of TSC, and I wrote the paragraph that's in the decision. Now I'm trying to send it, or it. So there are some moments like that where it's a little bit odd to be on the other side, and
It's like that
have
Spider-Man meme
words used against me.
Yes,
it's
100%.
the two Kristins pointing at one another.
Yeah.
Yeah.
But it does give you insight into where the weak points are. So anyway.
It's fascinating. I didn't know that about the union, and it's really interesting, because I do, as somebody who used to prepare immigration petitions, and sometimes we would make them really, really long, and we'd organize them the best we could with nice tabs and a nice table of contents. We're still submitting a massive paper petition that I know gets scanned into a PDF, and then most officers are reviewing them on their computers now. But nevertheless, looking at 500 pages of anything or 1,000 pages of anything and having, a target amount of time that you can spend on that to make a determination, I have a lot of empathy for, especially given the volume increase that we've been tracking, and what you guys just mentioned, the fact that like a lot of folks who are seeing these petitions, like it's not like they've been doing it for 10 years, right? And the evidence that they're seeing is ever evolving as the market's adjusting to the decisions that are coming out, especially increased denials, which kind of makes everyone panic and wonder, is my strategy that I've been using before working anymore? Do I need to pivot it? Now I need to change XYZ, and then it sort of snowballs into this whole thing where now no petition uh, looks the same as any other, and that just creates more complications. Um, the other thing that's sort of relatively new as we're recording this January 30th is a decision came out of Nebraska around EB-1A and sort of the final merits component of that. And we know that a lot of and you guys know this from working with clients as well, but we've seen it in our data that many of the EB-1A denials that are ultimately being issued are done so on final merits. Kristin or Melissa, either one of you can take this. Do you maybe want to explain, because you'll do a better job of than I can, explaining sort of the overview of what happened with that court decision in Nebraska a couple days ago?
Melissa?
Okay, yeah, I can do it. I'll just tell you it from like our lens, which
Sure.
was we started seeing emails from clients being like, hey, linking the decision and saying like, hey, how is this going to affect my case? Because one of the things we also do is we represent clients who maybe have previously been denied and are trying to file again, and some of them have been denied on final merits, et cetera. So I think for a lot of them, there was a lot of chatter online about, oh, wow, Kazarian is dead. And I'll back up a little bit. So this decision, and I guess I'll back up for individuals who aren't even more for individuals who aren't fully versed in the EB-1A world. But essentially, when you are adjudicating an EB-1A decision, there's kind of two prongs. The first prong is you have to meet at least 3 criteria. And then once you meet that 3 criteria, you go into what's called a final merits analysis. And they refer to this as Kazarian because it was created by a Ninth Circuit case that came out eons ago. And to be candid with you, Finn, these challenges on Kazarian are nothing new.
No.
And we saw them in every litigation case. I mean, not every litigation case, but I mean, if you're going to challenge a EB-1A decision, it behooves any litigation attorney to throw in a challenge to Kazarian as well, because it essentially was adopted by USCIS via memo. So there is a pretty strong rulemaking argument there. But candidly, the agency always used to win that argument. I mean, Kristin and I worked on many cases that were litigated, and that issue was discussed. But what was really interesting about the case that came out of the District of Nebraska is they actually found that the second step of Kazarian, the final merits analysis, was arbitrary and capricious. And it was notable for a couple reasons. First, it was in the District of Nebraska, which is a typically very conservative district where the agency is very used to getting very positive decisions. And second, it's in Nebraska, and the Nebraska Service Center is in that district. And so when you are suing from a jurisdictional point of view, you can sue where the agency adjudicated your case, meaning if you're an EB-1A, denial, you can sue in the District of Nebraska, even if you don't live there. So I mean, and it was done through a lens that posts the death of Chevron deference. So that was really interesting as well. So that's kind of an overview. It's a very exciting decision, and I'll maybe Kristy talk about how we kind of feel about it from a long-term perspective. But it definitely made a lot of news. It was definitely the next morning we had just a ton of emails from clients just asking how this was going to affect their case.
Yeah, there's certainly a lot of buzz and excitement around it from I think both like individual applicants who have a case pending or had a case denied, like you mentioned, or like prospective applicants. Like there's a lot of folks who are
Yes.
preparing themselves and trying to get themselves ready to apply and qualify and get approved for an EB-1A. Yeah, Kristin, I'd love to hear sort of your analysis of the case and maybe what happens from here, because I've heard a lot of optimism and a lot of excitement from one side, and then I've been talking with other folks who are former USCIS leaders themselves, and they're a little bit more skeptical about the longevity and durability of this individual decision at scale. So, what are your thoughts?
Well, so like Melissa said, we litigated this on the other side all the way through several circuit courts. I think I have like 3 circuit court decisions that say Kazarian is good law that I worked on. But when you're a lawyer, you work on whatever, you zealously advocate for your client. And at that time, our client was USCIS. Do I think that there are definite weaknesses in the agency adopting without rule and comment, notice and comment, Ninth Circuit case? Yes. Is there a weakness there with the agency? Yes. And the reason that I know that is because I've been on all those working group like meetings where those weaknesses are discussed. The other thing is that the agency is very litigation risk intolerant. When you litigate frequently, like we did, Melissa and I worked at this like service center law division where we were doing litigation on the regular, and we were very comfortable. We are very comfortable in that environment. But the folks who are driving policy at headquarters and the people who are like making decisions about reactions and agency policy are less they're more risk averse when it comes to litigation. So my take is that I think this will spur a conversation at USCIS. I think it already has spurred a conversation at USCIS, and I think there'll be an evaluation of where the risk is. It is one single decision. It's applicable only to that particular plaintiff.
Right.
But it does start a conversation at USCIS about whether this was properly done and what the risk is. I would assume they're probably trying to figure out how many of these cases are being denied just in final merits. And I think if I were a client, like if I had a client come to us with a denial out of Nebraska only on final merits, I would file a motion. And the reason I would file a motion is because the chatter around this case, I'm sure, has reached back to the agency, and they're not gotten guidance on how to handle it at this point. And there's a risk, and officers don't want to be overturned by courts or by the AAO. So there is a little bit of an opening, I think, and I do think that there will be there could be a faster tracked NPRM to get the any regulations that they're talking about moving out for faster. That's usually a very tediously slow process. So maybe that'll spur them on to move more quickly. I also think that this is a small immigration victory in a year of immigration defeat. And I feel like when there's a small victory for immigration applicants and foreign nationals, that's one of the reasons why this has been so widely publicized, and it feels good, and it feels like finally a court is stepping in and saying, no agency, you can't just make all the rules. You have to, Chevron is dead. You have to follow the rules, and we're going to make sure that you do. And so I feel like that feels good to people. It feels good to me, certainly. And for that reason, I think that's why it's kind of gained so much traction. But from a practical standpoint, it's kind of case by case. Like it doesn't apply to everyone. And I think Melissa and I have been through the decision in depth, and we've kind of picked out some of the pieces of it that we will now include in our filings because they're really good law. There's some additions to that policy manual that came out in December that nobody talked about, but that court talked about it. So
In December of 2025.
mm-hmm.
Oh, okay. I don't know. You talk about that a little bit. I haven't. No
No,
one's brought
just
this up
like
before.
so there was this understanding at USCIS when I was there and on the working group, and we were advising officers that they have to address evidence, right? Like a decision, in order for it to be legally sufficient, has to include an engagement with the evidence. And there's a lot of times where decisions are issued and the final merits analysis is very conclusory and lacks any engagement with the evidence. And so there's been some direction to that officers have to actually review the evidence and engage with it in order to create a fully legally sufficient decision. And so that's like great language to include in a petition where there's a lot of evidence. And the officers, some of them are my dear friends. I understand what they're up against. There's a timing. It's a model that is not, it's not set up for success. Like when Melissa mentioned that it's run like a private company, it's run like a private company without the advantages of a private company to make it more efficient. And so there's a lot of inefficiency baked into the cake. And so it's hard to get a case, have an hour and a half. It's 1,500 pages. I mean, we filed one that was 1,500 pages against all my, but there's a lot of evidence that has to be submitted. So, and all that to say, it's really tough. But that applicant is also paying a good amount of money and has a right to a legally sufficient, consistent decision coming out of the agency. And so that's the kind of language that I think is helpful from that Nebraska case that we, will start putting in our cases. And Melissa and I kind of have that, we kind of have that ethos at our firm. Like we're going to hold the agency accountable for a legally sufficient decision. And we get a lot of legally insufficient decisions that were filed by other people that people bring to us and say, what do I do? And, some of those are some of my favorite cases because I love being able to craft it again or respond. But
so it's really interesting. So sort of the ramifications of this on the market side are like twofold. It sounds like one, cases that were denied on the basis of final merits over, I think it's like since 2016 is what the ruling said, 2016 to 2025. Am I getting that right?
So Kazarian came out in 2010.
Okay, so it's anything since Kazarian to present day that have been denied. You're saying those cases, if for any clients who come to you, you can file a motion to appeal those denials and attempt to get the case reopened?
No, so if a case is denied, you have 33 days. So to file a motion or an appeal. Outside of that 33-day window, you're looking at litigation as an option only.
Got it.
No. Do I think we will be litigating cases in Nebraska over this? No, I don't think so. I think that there needs to be, Brian Green is doing a great job with that. And I think that needs to be continue. But that being said, if I did have a client who came to us and said, I have a denial out of Nebraska and it's only on FMD and the officer didn't engage with the evidence, filing a motion is their right anyway. And in that motion, if it's within that window, I think it would be very advantageous to say, look, this is the decision coming out of this district and you didn't engage with the evidence, and this court is saying agency must engage with the evidence. And so take another look. The thing about motions is that they often go back to the same officer, and that creates a bias. Nobody wants to be overturned.
Yeah. Got it. So then that's the other side of this is all new filings that you and other immigration attorneys are preparing on behalf of EB1A applicants. You're saying like there is now new evidence to include, or maybe evidence is the right word, but just like new citing the case in USCIS sort of back to itself, right? In those applications that now presumably those officers who are adjudicating those cases would need to address if they were to issue an RFE or a NOID in the same way that they did for this case that was challenged and ultimately overturned by that judge. Like, is there going, I guess to put the question a simpler way, like, is there going to all of a sudden the next 1,000 EB1A petitions that are filed with USCIS presumably going to lean on this judge's decision as part of the case?
Probably.
Yeah.
They should.
But that being said, this is nothing new. I mean, we've been arguing that the officers must engage with the evidence. I've been arguing that like since AAO, right? Like there's a lot of AAO decisions that speak to that where the AAO does a de novo review and they say the officer didn't address this set of evidence, right? Like the officer ignored this criteria, or this like argument or set of evidence completely. And that is arbitrary and capricious. And the fastest way to get, like when I was, and Melissa too, I think would share this, that when we were working there, the fastest argument to get an APA scare is that the officer did not address the evidence, because you can't stand on a decision. The agency can't stand on a decision where the officer doesn't address the evidence. That is by definition arbitrary and capricious. So from our perspective, when we were there, that would get a reopen immediately.
What are the like? Okay, so it's just interesting, and I'm probably speaking now just more as like there's a lot of immigration practitioners who listen to this. They may already know the answer to this question, but maybe I'll speak for like the global mobility folks and the foreign nationals who don't, and you could talk to me like them who don't know as much. But like one thing I think a lot about, and you referenced it before, like you submitted a petition that was 1,500 pages. Like the more I learn about how long USCIS officers actually have time to look at this, like I'm sure that I know that that's a difficult judgment call to make as an attorney, because yes, you need to present all the evidence, but you also know as two individuals who worked at USCIS for a really long time, like what is going to happen when that petition hits someone's desk or hits their laptop screen, right? Um, but there are all of these, like you said, this has been happening for a long time. This Nebraska case is the latest, but all of these AAO decisions, attorneys are citing back over and over again for different cases, and it's sort of like adding to the complexity that like a human individual USCIS officer, and you guys talked about sort of the training that they go through and getting cycled in and out of teams, has to try to absorb all of this, like when they're looking at an individual case. That just, to me, that just feels difficult. So how do you guys navigate that with your clients? Is it like case by case basis and you try to figure out what's best for each individual client, or do you have like an overarching strategy given the feedback loop that you're getting from USCIS right now? And the advantage that you guys have is having been there and been a part of being on the other side of many of these decisions for years and years and years that are still applicable today.
So we talk about that a lot with our clients, and we talk about the volume of evidence. And this is where I think having a good lawyer is kind of key, right? Because as Kristin indicated, there isn't a situation where if you're submitting 1,000-page packet, if you're submitting a 500-page packet, they're not reading every piece of evidence. They're just not. So your petition cover letter is vital to, number one, tell your story in a way that is interesting and tangible to the officer. We talk about this a lot with our clients we have to make you different than every other, software engineer, right? Like there are a lot of software engineers applying, and some of them are doing really amazing high-level things. But we have to tell your story in a way that the officer who has looked at 3, 4 other software engineers that day differentiates you. So number one, you have to be able to tell a really nice story that is tangible for the officer, that the officer can understand. But number two, your petition cover letter has to be really engaging, and it has to highlight the evidence and get the officer to be able to locate the evidence quickly, right? So sometimes we see petition cover letters that are just way too long. Once again, they're not reading all of that. So you want a tight petition cover letter that is telling your story and then getting the officer to all the evidence that is necessary, because they're just going down a checklist and they're, thinking about your evidence in a way that's just like, okay, do they have this? Do they have this? Do they have this? Do they have this? So if your cover letter can both address everything on their checklist and get them directly to the evidence that they need to eyeball to make sure that it actually says what you're saying it says, that's going to be an efficient petition. If you're submitting something, I'm submitting every single piece of evidence I can think of, and I'm writing my whole life story, and I think this is where a lot of individuals who filed themselves go wrong, who are doing it without an attorney, is they think that if they can put every piece of evidence and they can write kind of a book about why they're so exceptional, particularly in the EB-1A context, that of course they should be able to get approved. But really, it is a strategy game. You have to kind of know what you're up against. You have to know that the officers are looking at it on a computer. I mean, looking at something on a computer, a huge PDF document, is very different than when they used to be paper files, right? It's just a different experience. So you also have to consider, okay, when you're writing the cover letter, know that they're looking at it on the computer and they're going to have to scroll to get to your evidence. So you need to have your exhibits highlighted in a way so when they're scrolling out and trying to get to exhibit L, that it pops out easily and quickly and efficiently for them. So that's just some of the things you just have to, it's small things, but it's important things when you know the context and the situations the officers are dealing with. when they're looking at these petitions, because they're not sitting down, in a comfy chair with it, bound and like reading it front to back. They're just not. They don't have the time.
How do you guys sort of the way you just communicated that was very clear to me, right? It helps me understand the process a little bit better. But when you guys are communicating, I know this is a former paralegal, communicating to a client, what exactly you need from them, what you need them to go and do on their side and gather for you so that you can tell that story with the evidence they provide, can sometimes be one of the biggest bottlenecks, right?
Yeah.
How do you guys address that with clients, especially with look, with an H-1B petition, it's not that difficult. Like the standard is like pretty low
Yeah.
compared to an EB-1A or an O-1. Um, how do you guys handle that with each individual client? Like what does that process look like for a client that sits down in a consultation with you who wants to understand, okay, if I work with Kristin and Melissa, here's what it will look like on my end to give them what they need to give me the best chance of an approval and ultimately a pathway to citizenship in the US.
We have developed sort of guides that we've written based on decisions coming out of the agency and just our experience with these cases, that do provide lists of evidence that are good for the criteria. We also study very carefully the decisions that we see and that are AO decisions, although the non-precedent decisions haven't been released lately, which drives me crazy. But we study that stuff, and then we're constantly revising how we present these arguments. And so when we have conversations with folks, we tell them the best types of evidence that we see, and then we consistently work with them to gather. And then as we refine the arguments and as the cases develop, we reevaluate and we continue to look for things that are supportive. The salary argument in EB-1A is a great example. It should be very straightforward. It was intended to be very straightforward, and the decisions coming out of USCIS are so far outside of what is allowed that we've modeled our responses basically after the crazy NOIDs and RFEs that we've seen. I've even included language in this case that I'm filing this week that this is the stuff that's coming out of these NOIDs and RFEs, and this is ultra vires. It's outside the regulations, and so what we've given you is by policy manual sufficient. And if you want to challenge it, you're going to have to quote someplace in the policy manual that says this is required, because it's not, and I know it's not. So we sort of have a little bit of a, I would say, aggressive, Melissa, approach.
Assertive and somewhat kind of I think we try to get ahead of them because we know where they're going to go, right? So we know we kind of know what they fall back on. Oh, this is the I'm trying to think of a really good example, and the salary context. Yeah, we know their templates because we helped draft some of them, and we reviewed them, and we also told them and gave them feedback, because another thing we did at OCC was a lot of legal reviews. So if an officer had a really complex case or a question, they would send the decision to Chief Counsel's office for a review before it got sent out. And so we are able to kind of, know what some of the arguments are going to be. So we try to kind of head that off in the petition cover letter with the initial filing, so that they, can't make that argument, or we can kind of get ahead of it. Or what I like to think of, and we were talking about this a little earlier, but there's a component of this that is creating the best petition that you can for a client. But then there's a aspect of it that you can't control. That's just luck, right? It's whose officer's desk you land on and how they are going to, what lens they're going to view the petition at during that day. So I think you have to always be kind of thinking, and maybe this comes from our background with the litigation, but you always have to be thinking about the record. You always have to be thinking about preserving the record. So while sometimes, you might be kind of hedging your bets on making an argument, I want that in the record. So if I have to sue you, I can show to the judge that in my initial submission, I already addressed this and the agency ignored it.
That's why Melissa's amazing.
I don't know about that.
Yeah. Having a litigation background and then preparing these from the get-go is just fascinating, because So I saw someone say this, but every EB-1A is filed with a litigation in mind.
Well, especially it's a great segue into what'll probably be my last question here for both of you. Especially in an environment where right now maybe 4 out of every 10 EB1As that are being reviewed by USCIS are being approved, according to our data. Maybe 3 out of every 10 NIWs, and that's a shift from this time last year where it was 6 out of 10 for NIWs and 7 out of 10 for EB1As. And so what I was going to ask you guys is like, and I know again you've only been on the other side for a few months now. You're just getting the practice going, and you'll have many approvals to reference in the future here. But how reliable do you think it is to reference the strategy used for an approval in a past case for a new case that comes in that maybe has a similar the applicant has a similar background or a similar attributes, given sort of the rapid downward trend in the approval rate for those two key categories. And again, a little bit in O1 too. We talked about it yesterday. Approval rate historically for O1s, and USCIS still reports it as of June 30th, 2025 was 93%. We're tracking it now. It's kind of in the mid 80s, right? That's going down too. How reliable do you think like a previous approval is as a reference point for a client that comes in with a similar background or similar attributes? Like, can you rely on that, or do you need to come up with individual strategies based off of the feedback you're getting in real time from those denials and from those RFEs and from those NOIDs, more so than before?
So I think that there's a lot of firms that use what they would call a template. And every lawyer has language that they use in many of their cases. We have language that we use in a lot of our cases. A lot of it has to do with like the background of the law or certain policy manual references. But that said, by definition, somebody who's applying for EB-1A is claiming it to be extraordinary. So that by definition means that they are not just like everyone else. And creating a petition that is just like every other petition isn't going to work. And I think what we're seeing partially is that there are a lot of petitions that were filed a while back, and that did work. That model was very successful. But now I think there's an increased scrutiny on these cases, and I think that the templated approach or the standardized approach, one size fits all, doesn't work. And it shouldn't work because these folks are extraordinary and you have to explain their uniqueness. And I think we do a good job of that. The other thing I will say is that we represent a lot of people that are at the big FANG companies, and some of the stuff that they're doing is so technical and it's cutting edge. And I'm 50 years old and I'm behind the 8 ball, right? Like the technology is moving rapidly, but I'm no different than an officer. They don't understand it. It has to be translated. It has to be explained to them in a way that is real. So that's part of our job. Melissa puts it so well in our consultations when she says that we're basically translators. Like we take what is so unique and extraordinary about their decision or about their work, and we tell their story in a way that the officer can understand. And you can't do that with a template. So,
Melissa, anything to add?
Oh, no, I think she hit the nail on the head. I think if you're a good lawyer, you have to look at the specific evidence of your client, and then you know where the weaknesses are in that case, and then you know how to structure the cover letter. And it's going to be different for every single client because every single client, they might have similar backgrounds, but they're going to have different evidence, and they're going to have different weaknesses and different pros in their case. So, if we get when we get an approval on one case, we're thrilled. Are we using that to show that we can get that same type of, occupation in EB-1A later? No, it's a totally different calculation. I think you have to really individualize how you're presenting these to the agency, at least right now in the world we live in right now.
Yeah, I love it. Well, we covered a lot in this conversation, and I maybe can cap it off with just one short question for you both, and you can take it sort of in any direction you want. But it's a new year. It's 2026. We're about to round out the first month of it. You guys are going into your first full year of private practice after long, successful careers in the government. What are your expectations for 2026? I guess like I'll frame it not for your business, because I hope and expect your business will actually be quite successful, but just like more broadly for the overall immigration market, what do you think things look like at the end of this year compared to where they are now?
So I'll kind of speak in just regard to the employment context.
Sure.
I'm very interested to see what proposed rules the agency is going to put forward. I think they said that it was going to be issued in January. We're right at the edge, so we haven't seen anything. I am optimistic that it's just going to be, there's been a lot of fear that they're going to, change, for example, like how many criteria you have to meet in an EB-1A or something. I am hopeful that that's not the case. I think there's going to be stronger definitions and maybe a little bit more stringent review. But I don't think it will change massively. And I'm hopeful for, I think when the H-1B world has been in such flux, we're seeing a lot of people who are really nervous. So for EB-1As and NIWs is, for a lot of people, their only option. So I think that there's going to be a lot of individuals kind of thinking about that and pursuing those avenues, because for a lot of people, that's the only option left once their, H-1B timelines run out. So that's what I'm predicting we'll see a lot of in 2016.
2026.
2026, not 2016. I'm just wishing we're back into it. It feels a little well, I don't know. It feels a little a little bit like
deja vu.
2016 adjacent.
Yeah, exactly.
Yeah, 2016 adjacent.
Oh my gosh.
Yeah. Kristin, anything to add from your point of view?
I would just add that, I very, very much respect everybody that works at USCIS. Like when we left OCC, OCC lost a third or more of its lawyers, and those people are they're the brain trust of USCIS and of immigration policy. And so there was a huge loss for the agency. And I think that there was a conversation around, federal employees and all of those things. And I so respect the people that are still there. There are many of my dear friends at OP&S and at AAO and at OCC. And I'm hopeful that that some of the policy initiatives will be tempered by folks who have a really strong understanding of what is legal and what is within inside the regulations and the statutes. And I'm optimistic that that things will work out over the next couple of years due to the enormous trust and talent of the folks that are still there. And I also think that there should be a conversation around the insane value that these people who are applying for these categories bring to our country, and valuing that type of legal immigration, I think, should be part of the general conversation. That's from a business perspective, from an economic perspective, from a social perspective, and just as a country, who do we value, who do we want, and who are we willing to, provide permanent residence to, so that their talent and work doesn't go to someone else. And so I hope that can become more of the conversation.
It's one of my favorite things, following so many immigration attorneys on LinkedIn, is to see when they post like their success stories. Like, hey, we just got an approval for, they don't name the individual most of the time, but they'll explain sort of like their credentials and who they are and the type of work that they're doing. And it's like, you read through those and it's like, man, pretty glad that person's in our country. That seems quite important. So
we have a lot of those are the stories that need to be told. I mean, that's the stories that need to be told. There are a lot of really incredible people doing really amazing work that we want to keep here.
Yeah.
Yes.
Absolutely. Well, on that note, guys, this has been super, super great. I learned a lot in talking with both of you, both from, obviously your breadth of experience at USCIS and now being out in the private sector. And I'm really happy you guys are. I think it's a big loss for USCIS, but I think it's a big gain for a lot of your clients and future clients who are going to have the chance to work with you. So again, I really appreciate you both coming on.
Thank you.
We appreciate you and Lawfully, and thank you for inviting us.
Thanks, guys. All right. Bye, everybody.